We've heard a lot about the shortening. Of course, a lot of you know that there's quite a few legal issues continuing to be pending with the airport. NBA's position is that we want to make the shortening a temporary one. As we go through the legal action that we have, ultimately our position is, should we prevail in court, the city will have to reverse what they've done now. And to explain a little bit more about that, we have Joel Silversmith with us. Joel is a partner at Zuckert Scout and Ressenberger. The law firm has been an external counsel to NBA for airport access issues for many years, and Joel's experience in FAA, DOT, and other regulatory law and compliance has just been invaluable. So please welcome Joel.
Okay, thank you very much, Alex. For most operators at the airport, their big concern is going to be, what can we do today? But underlying all of that is the legal dispute that's been going on at Santa Monica for decades. The position that NBAA takes, as Alex has said, is that this is an airport that has obligations to the federal government that require it to maintain its facilities in perpetuity, but there is a lot of money and a lot of argument being made on the other side, which is how we've ended up where we are today. So just a quick little bit of background to explain how we've got to where we are at the start of 2018. The airport itself is about 100 years old, but the element that we're most concerned about is that during the Second World War, the airport was taken over by the federal government and operated as a military facility for several years. At the end of that process, it was returned to the city of Santa Monica through what they called an instrument of transfer. And this instrument required the city to continue to operate the airport and to operate it as an airport in perpetuity. In addition to that, in the 1980s, the airport also accepted grants from the federal government that required it to operate as an airport for 20 years. But in addition to taking these grants, there was an additional revision to the grant that was accepted some years later, and which we argue, and the FAA has taken the position, extend the airport's obligations through the year 2023. So from our perspective, there are two obligations on the airport, one which require it to be an airport with a full-length runway until the year 2023, and another which require it to be an airport with its full-length runway forever. However, the city has pushed back against this, and in fact has pushed back against FAA regulations since the 1960s. When we look at the situation as of a couple of years ago, we have them initiating litigation to challenge both the 2023 date and the perpetuity obligation, as well as taking actions on the field to try to disrupt operations. For example, arguing that they have a right to replace the Atlantic FBO with their own facility, which technically they do, but we have questions about whether they were sincere in trying to operate an FBO that would really serve the interest of airport users, as well as refusing to extend leases for tenants. And this had become such a severe problem that towards the end of 2016, the FAA had actually initiated an investigation of practices at the airport out of concern that they were drifting quite far out of compliance. However, much to our surprise, and honestly to the surprise of almost everyone involved, in January of 2017, the FAA and the city had announced they had entered into a settlement agreement to resolve the long-running disputes about the airport, essentially, from our perspective, giving away far more than we think was appropriate. The FAA said that the city could immediately reduce the length of the runway to 3,500 feet, as well as only have an obligation to continue operating the airport through the end of 2028. Now, it's important to note that that does not mean that the airport necessarily would close at the end of 2028, but that the city would have the option to do so. And given the current political environment, the City Council has actually adopted a resolution stating that they fully intend to close the airport at the end of 2028. That said, that is some time off in the future, and there's certainly a lot that can be done on the political front. But focusing on the legal side, NBAA, along with various airport tenants and users, responded to the settlement agreement by filing a lawsuit in the U.S. Court of Appeals in Washington, D.C., arguing that this agreement was beyond the power of the FAA. There are a number of different issues involved, but an example is that it's fairly well established that if the FAA releases an airport from its obligations, it has to document that doing so actually benefits aviation. So an example of this would be if a community wants to close an older airport and replace it with a newer, larger facility, the FAA would almost certainly conclude that the closure is justified. In this case, though, there are no clear benefits to aviation to the shortening. In fact, it's certainly a negative, not just at Santa Monica itself, but to the extent that traffic at the airport is going to move elsewhere at the LA basin, creating congestion and creating problems elsewhere. The FAA and the city have responded to the lawsuit. They argue that it is substantively justified and also argue various procedural issues, arguing that the court case hasn't even been brought in the correct form. We've responded to it. It's been fully briefed. But unfortunately, the wheels of justice turn slowly. So at this point, we're waiting for an oral argument date to be scheduled by the court in Washington, D.C., which probably will not be until sometime later in the spring or later in the year. We do hope that we will have a decision by the end of the year. And as Alex said earlier, we certainly hope that decision is in our favor, finding that the settlement agreement is invalid and that essentially the city has to restore everything to where it was at the start of 2017. This is obviously an issue we'll be continuing to monitor quite closely, and also other issues that stem from this. For example, as was pointed out by Gregory earlier, the Atlantic FBO has a 3-year lease term, or is negotiating a 3-year lease term with the city, but we'd certainly like to make sure that there are fair lease negotiations with all airport tenants, and there aren't any kind of unfair access restrictions put in place. If people listening to this webinar have concerns along those lines, please do contact NBAA about them. So as indicated earlier, NBAA and its allies are going to continue to monitor the situation at SMO quite closely. We certainly hope and expect that the court in Washington, D.C. will issue a decision in our favor, but that's not the end of the story. We're certainly going to need to work with our local supporters, with the authorities in the city to preserve the future of the airport. So this is something where we will certainly continue to publicize the status of issues at the airport and certainly appreciate the support from the aviation community. One other issue that I wanted to note, though, which stems out of the shortening of the runway, is that there are noise monitors at SMO and somewhat unique noise restrictions. Typically, the FAA does not allow noise restrictions to be implemented at airports without a fairly detailed study and approval requirement, but noise restrictions that predate 1990 are actually, quote, grandfathered, and the restrictions at SMO are part of that set of restrictions. However, the restrictions were put in place on the assumption of a 5,000-foot runway. That runway, of course, has now been reduced in length, and takeoffs will be much lower over the noise monitors than they were previously. We are concerned that this could result in aircraft who previously been able to operate at Santa Monica within the boundaries of the existing noise restrictions to now be in violation. This is something where, again, we will work with the airport and the community and the FAA to try to determine how this matter can best be resolved. But in the meantime, if operators are receiving violation notices or have concerns about their operations at SMO, please do get in touch with NBAA so we can try to assist them. And with that, I would like to hand it back to Alex.
Thank you very much, Joel. That was very insightful and helps us understand what lies ahead and the fact that the 3,500-foot runway may not be permanent at Santa Monica.